All rise. The Court of Appeals Division 1 is now in session.
Have a seat, I'm sorry. You'll line whatever you don't want, just throw on the floor, right? All right. And good morning, folks. We are here for oral argument in one UB21 0271 and 0272. They have been consolidated for purposes of argument and ruling. It is Ryan Harwick versus Freeport McMoran and the Arizona Department of Economic Security. So we are here for oral argument. Each side will have 20 minutes. You'll argue from the podium. We are recording and live broadcasting these proceedings. So I ask that when you come to the podium, please state your name and the party that you represent. You are welcome to reserve time for rebuttal if you wish, but we do not keep track of that. So keep track of your own time. Although you're welcome to announce it, I just won't stop you at that moment. We have read the briefs. We have conferenced the case, so we are very familiar with the case and looking forward to your argument. So understand that you don't need to just repeat the briefs. It probably is not your best use of time. Again, you do it 20 minutes. You don't have to use all of that time, but use the amount of time that you feel is appropriate. Right, counsel?
Thank you, Your Honor. Good morning, Your Honors, and may it please the Court. My name is Mark DePasquale. I represent the appellant, Ryan Harwick. In this appeal, Mr. Harwick requests that the Court reverse, or at a minimum vacate, the decision of the Appeals Board of the Arizona Department of Economic Security that retroactively found that Mr. Harwick was ineligible for unemployment benefits from May 3rd, 2020 through September 12th, 2020. And also found that Mr. Harwick had been overpaid $13,800. This morning, I would like to focus on two of the issues raised in our briefs. First, the substantive question of at what point in time should allocation of severance pay begin to be made. Mr. Harwick has taken the position throughout, and we have taken the position on this appeal, that the allocation should not start until after August 31st of 2020, when his company terminated him. The department determined that the allocation should take place as of the date of the unemployment benefits began. The second issue I would like to discuss is the ALJ, whether the ALJ abused his discretion when, after Mr. Harwick indicated that he wished that he had counsel but could not afford it, that the proceedings should have stopped at that point, or at least at the beginning of the proceedings, more investigation by the ALJ should have been made as to whether or not the proceedings should have been continued so that Mr. Harwick could obtain counsel.
So, counsel, if I could just jump in, what is your sort of best and fullest statement of why your client was rendering services within the meaning of 321B2 up to the time of August 31st?
So, Your Honor, I think the answer to that is the information that my client gave to the appeals board, and that is that he was, during that time, that May to August time frame, still required each week to report to the company to tell them, his whereabouts. And there was also, in addition to that, a limitation on his ability to look for work from a competitor of his employer. Now, his employer, Freeport McMoran, is a mining company. He's a mineralogist. So that's a fairly significant limitation for a mineralogist. So in terms of if we're looking at accepting the argument that we've made that the determination is when the provision of services is concluded, then we would say that he was providing services just by being available, by having to report in every week, and by being limited those were advantages for his employer because he was basically at their beck and call.
So you're basically saying he was a standby mineralogist for Freeport McMoran. That was kind of a fair summary of his service.
Yes.
Okay.
And so, turning to that issue, then I guess, and to jump into it, the disagreement, the substantive legal issue there, where we differ from the department's position, is that our position is that under the statutes, it's the time of provision of services, not the time at which the unemployment insurance was started. So the Arizona statutes govern the period for allocation of severance pay. And under ARS 23621C, the time for allocation depends on whether there is a written contract between the employer and the claimant at the time of separation. If there was a written contract, allocation is made according to the terms of that contract for the number of workdays that would be paid. If there's no written contract, then the allocation is to the appropriate period following the last day of the performance of services. And that's the one that
here there was a written contract.
I'm sorry, Your Honor?
Here there was a written contract.
There was a written contract, Your Honor. The difference here, I think, is that what the statute says is if there was a written contract as of the date of the termination. And in this case, there was, at least the record shows from Mr. Harwick's testimony, there was a written contract, but it took place, it was entered into after the date.
What date was it entered into?
Your Honor, I have it here somewhere, but it was shortly after the August 31st. It was within a few weeks. I can probably find that there at some point, but it was definitely that there was the termination, and then there was the negotiation for at least as far as the severance goes. I will say that. I'm sorry.
So tell me again, so as of the date of the statute or the written contract is what you're hanging this on, really, that it has to be the date of the contract and can't be allocated before that?
No, Your Honor. What I'm hanging it on is that it can't be allocated before the last day of performance of services. And so here, that's only, but it's still supposed to be allocated under the written contract. That doesn't have anything to do with the performance of services. If the written contract said this is effective May 1st, that's what would control, right, under the statute? Yes, I think, Your Honor, the only, and I'm sort of arguing a little bit against my own position here, but I think if you read the statute, what the statute says is they look at whether there was a contract in effect at the time of the termination. At the time of the termination was August 31st of 2020. That's when they told him, you're now laid off, the furlough is over. After that, there was...
In the absence of the written contract, do we know that, though?
In the absence of the written contract, you don't have anything in the record that says that, other than, I think, the testimony of Mr. Harwick.
And again, that wasn't developed at all further by the ALJ. So we have Mr. Harwick's testimony about what this contract says, the terms thereof, but my understanding is Freeport didn't have anyone there.
Correct.
The case agent wasn't there from DES.
That's right.
Okay, so and the ALJ didn't ask any questions about to plumb the depths of what that contract was.
That's right, and I think that may be in part because the ALJ has decided that it was irrelevant to their determination, because the department was taking the position that the relevant date was the date that Mr. Harwick applied for the unemployment benefits, not the date that was set forth in ARS 23621.
So I believe the ALJ made a statement acknowledging a continuing relationship with Freeport McMoran during this.
I believe there was some statement to that effect, Your Honor, either by the ALJ or I'm trying to remember, the appeals board had sort of, in the context of sort of recognizing that there was a continuing relationship, but that didn't matter because they had taken the position that the relevant date was the date that was in which he had applied for unemployment benefits. But yeah, I think there was some statement to that effect, if I recall.
Can one be, under the statute, can one be employed and still apply legitimately for employment benefits? Don't the statutes allow for that?
Yeah, so it depends on what your definition of employed is. But so for in the vernacular of the employed, the answer is yes, because the statute provides that either you have stopped performing benefits, or in the alternative case, the one that we're arguing here, if the claimant is making less than what they would be making, getting their benefits for in that time frame, even though they're still working, they're still unemployed for purposes of the definition of the statute, which would allow them to then go ahead and get unemployment benefits. So yeah, you can still be employed in the vernacular, but unemployed for
purpose of benefit.
Right.
To grant you the relief you're seeking, don't we need to find that the ALJ's findings, which were that he had to report weekly, I believe those were specific, that he was limited to what other work he could do because he could not work for a competitor, that he had this ongoing relationship, that those three things as a matter of law constitute providing services for purposes of unemployment. Because I don't know how we get there unless we say those three things are, as a matter of law, not fact, but a matter of law, providing services.
So a couple of things there. I think the answer is if you grant the relief that we're asking for in terms of reversing and that being it, then I think the answer to that is yes. I don't know if they have to all three be, but at least some of those have to satisfy the standard of having been providing services. I want to be
have
careful.
less than three? Is there one that's more dispositive than the others? Those are the three we have.
I don't know that there's one that's more dispositive than the other. So I think if I don't know that there would be any basis to say, well, we believe these two and not this one, but in any event, I think that's right. I want to be careful, though, because in terms of the findings of the ALJ, I just don't want to. I'm not sure that I remember the ALJ specifically making those findings as opposed to the appeal board making that. And so I don't want to misstate something there. I think the issues were definitely raised by Mr. Harwick with the appeal board. And the appeal board has the ability to consider all of that. And
So if it's the appeals board's finding, I'm not concerned about which one it came out of.
So,
because
yes.
the appeals board
Yeah, the
can do
appeals
that
board.
review.
Right. Yeah. So I just wanted to make sure that
Yeah.
we're on the same page there.
Counsel, do you agree with ADES's use of the definition of service in Black's Law Dictionary in so much as it indicates a conferral of benefit? And can you comment on whether your client conferred benefit on Freeport?
I would take a quick look at what the definition was there, but without looking at the definition.
X for the benefit of another.
Yes. Well, I would say, so the answer to that is under that definition, Mr. Harwick was acting for the benefit of his employer at the time in the ways that we have described. He had to contact them every week. That's a benefit to them. He's on call. He's ready to step back in if they need him. So that's a benefit. He's precluded from going to one of their competitors during that time. That's a benefit. So yes, I don't disagree with that definition, and I think we'd fall well within it.
Should the concept of benefit be part of how we construe services rendered under 621C2, and if so, why?
So I guess in terms of, I don't know, I'm trying to think about that a little bit, Your Honor. I mean, I think that are there services, I'm trying to think under a circumstance under which services rendered would not be a benefit. And so, I mean, I suppose if they could come back and somehow say, well, you rendered services, but they didn't help us.
But they asked for these services to be rendered, so we're not in that territory, are we?
Right.
Okay.
Yeah. So.
If the department's going to rely on services, don't they have to, or benefits, don't they have to expressly find those benefits and what they are based on the evidence presented? Can we just infer them up here?
So I think my answer to that would be this, that they, in terms of the benefits, because they weren't doing the analysis under that benefit analysis, they didn't make those findings. The evidence that they, I'm sorry.
No, but I was just going to say, and I don't want to take up too much of your time with this, but so the bottom line is if we accept the idea that the benefit needs to be a part of the analysis, because findings weren't made, when we have to reverse and remand on that alone?
So I guess my answer to that would be this, twofold on that. One is that the evidence that they had is the written submission of Mr. Harwick to the appeals board, where he said that these were the benefits. That none of that was contested either by the internal department people or by the former employer. And so you could remand to have them assess that, but they're going to be, unless we go to the next issue, which would be the sort of the due process issue of doing this whole thing over again, they're going to be looking at the same evidence you are, and there isn't going to be, they're not going to have the benefit of having heard testimony or whatever. It's going to be based on the submission that my client made to them, the written submission that was not opposed. And so I'm not sure you're in a different position than they would be to make a determination.
Well, and not just not being opposed, but I mean, the ALJ wrote, although the claimant may have had an ongoing relationship with the employer, didn't the ALJ functionally find that your assertions were true but irrelevant to the legal question? Isn't that what the ALJ really did?
Yeah, or the appeals board, I think, yes, but yeah, one of them, yes. I think that's right. So I guess in that respect, they did make the determination of that, but then said that it was irrelevant. And so under that analysis, you wouldn't have to remand because they'd already made that statement.
And just 20 seconds at best, but if we accept your argument on the due process issue, does every ALJ have to stop every hearing if the person says, gee, I wish I had a lawyer, I really need a lawyer to help me with this? Wouldn't that become the outcome? Almost a right to counsel, though not paid counsel.
I don't think so, Your Honor, for this reason. I mean, I think what the ALJ might have to do is stop and say, all right, you say something like in the Martin case, what the ALJ did there, because there he said, you're appearing by yourself. I assume that you don't want counsel, and she waffled back and forth and and sort of said, well, I kind of maybe I do, maybe I don't, and finally decided she wanted to. And he said, well, what do you want to make a motion to continue this hearing? Yes, she said, and so he actually brought the issue up. Talked to her about it, got all of that on the record. Here, by contrast, the ALJ, when Mr. Harwick said, I really wish I had counsel, but I can't afford it, he said, oh, that's okay, we do this all the time, and just sort of went on as if he didn't really need counsel. I do think what it would require would be that the ALJ at least stop long enough to say, you realize that we provided you with this material that said, that you can have these resources. The answer to that is, my client tried to use the resources, and they weren't available. He tried to call, and he would never get any response. And so I think there's some.
But counsel, your position isn't that the department has an affirmative job to pay for this like a civil Gideon, right?
Correct.
So if he tried and he wasn't available because the resources just weren't there, doesn't that strike you as futile?
Well,
I mean, what was the ALJ supposed to do at that point? I mean,
Well, I
what
think
would
the
have
ALJ
cured it?
What the ALJ could have done is what he did at the end, which is to say, I have, here are our resources. Have you tried this? Have you tried that? And I think at a minimum what he could have done is say, let's continue the hearing. There was no reason why the hearing had to take place on that date. So he could have continued, he could have said, look, why don't you go down there and talk to them and see if you can get something. We'll continue this hearing to see if you can get counsel. That's what I think he should have done, which is sort of akin to what happened in the other case. So I don't think it was futile. At least she should have been given another opportunity. I guess I only have 38 seconds left, so thank you.
Good morning, Your Honors. May it please the Court, my name is Jennifer Bloom, and I'm here today on behalf of the Arizona Department of Economic Security. And I want to start out with the allocation issue. And it's very clear from all of the relevant statutes and regulations concerning unemployment that employment for the purposes of the statute is connected to earning wages. If you are, for example, working part-time, you might still be entitled to unemployment, but that's only if you show a diminution in your typical amount of wages that you would be earning. And in fact, the allocation statute 621 repeatedly talks about wages being payable to the individual. So if we're going to say, oh, you can be eligible for unemployment as long as you're performing services, that would essentially say, well, if you're volunteering, now you're eligible for unemployment because you were doing services, even if you weren't earning wages. So I think it's very clear from the context of the statute and the context of the unemployment benefits program that when we're talking about performing services, we're talking about services for wages, not just services.
Your use of the word volunteer is really interesting, counsel. Do you regard Mr. Harwick here as some volunteer for the benefit of Freeport-McMoran, or is that different?
No, Your Honor. That was purely for the sake of the context of unemployment benefits.
So was Mr. Hardwick's furloughing, was that volunteering? So he was voluntarily restricting himself from working for Freeport's competitors?
No, that's not my position. I purely referenced volunteers to point out that unemployment benefits in general are about performing services for pay. I'm not making any sort of implication whatsoever that Mr. Harwick was a volunteer or that he volunteered to not work for competitors. I would point out, though, that his position is very similar to somebody who is under a non-compete agreement. And I would think that it would be very odd to find that someone who is under a non-compete agreement is performing services for their old employer. Non-compete agreements are a fairly common practice, and I would think that would be a major departure from the state of the law to say that if you're not allowed to work for competitors, you're still performing services for your old employer.
But you would agree with me that non-competes usually are in the form of a contractual relationship and thereby must be supported by some sort of consideration?
Yes, that I would agree with that. That is true.
Okay. So are you saying that what was the consideration that Mr. Hardwick got for not competing?
I do not Not sure about that. I don't know any of the specific details of his arrangement with his employer. So if he was receiving any kind of consideration, or if the severance pay was considered consideration, the contract that he entered into with his employer at the time of his termination or shortly thereafter is not within the record. So I actually don't know what the terms of that agreement were. And as far as the due process claim, I wanted to point out that in the Martin case, which Mr. Harwick relies on, there's actually a footnote, which admittedly is dicta, but footnote 1 specifies that if the appellant in that case had been informed prior to the hearing that she did have the right to have counsel, that it would have, and she chose to show up without counsel nonetheless, it would result in a waiver of her right to counsel. And here I don't think it's in dispute that Mr. Harwick was advised in his notice of hearing, both notices of hearing, that he had the right to have counsel when he appeared. And he was obviously aware of that right because he talked about how he had attempted to find counsel. And when the ALJ at the conclusion of the hearing pointed out that these are some resources, those resources specifically were about how to apply for a waiver, not about the issues that were in front of the tribunal, which might very well have been distinct and separate resources.
Are those resources funded by the department? Meaning, are they guaranteed to anyone who applies for them?
My understanding, and I don't want to necessarily give you anything that isn't correct, but my understanding is that the message board that the ALJ referred to was for a nonprofit organization. But I'm not 100% sure on that, Your Honor.
Okay. Does your client self-provide any of those kinds of resources?
Not that I'm aware of, but I can't make a completely accurate representation on that point.
Can your client prevail if we don't find as a matter of law that the weekly reporting, the limiting the work relationship, and basically being in a standby situation, that with those three things, as a matter of law, that is not a sufficient relationship to satisfy the statute?
So,
Isn't that the only way your client can prevail?
I believe that you would need to find that he was not performing services under the statute as a matter of law.
What I'm saying is that those couple of things are not providing services as a matter of law.
I do think that's correct, Your Honor.
Okay. Was there any credibility finding on the part of the ALJ that would suggest he didn't believe something from Mr. Harwick?
So I was actually just looking at the ALJ's findings and the board's findings, and at least in my cursory glance, I did not find any specific findings as to whether or not he was continuing to check in or as to whether or not he had to refrain from working for competitors. I can say that he did not actually present to the tribunal that he had to refrain from working competitors. That evidence wasn't before the tribunal, so the tribunal could not have made a finding of fact as to that. And as to the board did make...
The tribunal admitted the petition.
I'm sorry,
His petition for benefits, and it's in his petition, right? And that was admitted into evidence. He had to sign off on it as being true and accurate.
Yes, he did.
So isn't that evidence before the tribunal to make that finding?
I do not recall seeing that there, but if it is, and I will take Your Honor's word for it, then yes, that would constitute evidence.
But the tribunal didn't express any skepticism about his testimony either by the same lights. They didn't say, he's not credible, he didn't really do that. There's no such finding in this record, counsel, correct?
That is correct, Your Honor.
Okay, and I'd like to go back to this notion of bargain for benefit in the discussion about non-competes that you had with Judge Faruya. I think that's very interesting because in your brief you talk about the relationship between the concept of service and the concept of benefit. Do you believe that by being a standby mineralogist that Mr. Harwick was conferring any sort of benefit on Freeport?
Yes, I would concede that. He was available to them if they needed his services.
So he was subject to rehire, he was calling in, he was there if they needed him. If the pandemic evaporated on August 1st, 2020, they could bring him back into an office and have him resume his mineralogical duties. They wanted to know that he was there, right?
Yes.
Okay, thanks.
And that's why I think the case law under the Fair Labor Standards Act is actually very helpful in this situation. Because if we're talking about employment, this is what the context here is, employment or unemployment, then case law that tells us when you're employed and you have to be paid wages, I think is actually very analogous to this situation. And if we look to that case law, it's very clear that there's a difference between waiting to be engaged and engaged to be waiting. And one of those is compensable time, and one of those is not. And what Mr. Hardwick was doing here was the waiting to be engaged. And under all the case law, under the Fair Labor Standards Act, that's not compensable time. And similarly, being required to check in once a week is not considered compensable time. So
if your opportunities for alternative activities are constrained by the requirement to make yourself available for your employer, is that not being engaged to be waiting? I mean, the case law talks about firemen and policemen and doctors who can't go drinking, right? Mm-hmm. Can't leave a specific area. So that trip to Hawaii, no, that can't happen. The drinking party with buddies, that can't happen, right? It's a significant burden or constraint on an individual's freedoms that differentiates, at least as far as I recall the case law, whether you're waiting to be engaged or engaged to be waiting. Do you agree with that, or am I misapprehending?
No, Your Honor, that is correct. However, the cases then also, they make it clear that if the only constraint is that you have to be available to report for work, you are waiting to be engaged.
I agree with that, but didn't we just talk about how Mr. Hardwick could not work for another? So, like, Freeport is saying, you're my mineralogist, I haven't fired you yet, okay, and I don't have any work for you. But if you want to go over and work for this mine and rockhound for them, knock yourself out. I would definitely agree with you, but that's not the case here, is it?
Well, I think if we analogize it to those cases under the FLSA, if you're a doctor and you're on call, you need to be able to show up when that little pager goes off. You can't go and work for another hospital because...
Our statute doesn't say rendering services under, as provided in the FLSA. That's not the standard here. We're looking at something different. And we're looking at it from a policy of compensating employees, not compensating them, or people who are out of work. So why should we read services why should we even look to the FLSA under these circumstances?
I think it's exactly what you said, Your Honor. We're talking about compensating people because they are out of work, so work that they would be getting paid for. So when we're talking, since the whole compensation scheme is related to whether or not a person is earning money for employment, I think it does make complete sense that we should look to whether a person is entitled to be paid when we're considering whether or not they were performing services.
So did the department have any obligation to get this written contract to assess this?
I don't see how they could have. The department was not in possession of this contract, had no access to it. I believe Mr. Hardwick mentioned that the contract contained a non-disclosure agreement of some sort. So I don't know how the department could possibly have any ability, let alone a burden.
So nothing here is the department relying on the existence of a written contract. I want to be clear.
Yes, the department is not relying on the existence of the contract between Mr. Hardwick and its employer because it's not in the record and we don't know what it says.
And Counsel, this is more a statement than a question, but I invite your response, of course. I guess I'm a little troubled by the FLSA analogy, both because of what Judge Goss said, which is it's not in the text of 621, but also kind of separately because that argument has the effect of converting everything Hardwick could do into being a mere volunteer. And you're like, well, I'm not saying he's a volunteer, but that argument kind of carries with it that implication. You have any comment or response?
I'm not sure exactly. Mr. Hardwick could have worked for a company that was not a mining company. This is my understanding of the terms of this, and he could have gotten paid for working at any employment other than a competitor with Freeport McMoran. So he was not limited to volunteering during the course of his furlough.
Because they specifically designed the context of the relationship to eliminate only those things that they didn't want him to do.
Yes.
Okay, thanks.
I believe I've said everything that I wanted to say on the allocation issue, unless the panel has further questions on that. Briefly returning to the due process issue.
I'd like to, before you move on from that then.
Of course, Your Honor.
The benefit. There's been no finding of a benefit here at all, has there?
No, Your Honor.
So how do we even deal with that up here? ADES never raised the idea that there needed to be a conferred benefit or the absence or the benefit issue.
I think that if this panel decides that they can't determine either as a matter of law, either that Mr. Harwick's services did constitute, Mr. Harwick's actions did constitute performing a service or did not constitute performing a service, and felt that he needed a determination as to whether he had performed a benefit, then I suppose the correct remedy for that would be reversal to the board for that finding. And the board's finding on that issue is simply he may have had an ongoing relationship. So I would submit that may is it's not a finding one way or the other. They're not finding that he did. They're not finding that he didn't. It's essentially a non-finding.
So as Judge Goss remarked earlier in the question, you have in evidence and in the record his averals and his petition. And as you conceded earlier, there is absolutely no finding that those averals are incorrect or wrong. And the appeals board is indicating claimant may have had an ongoing relationship. But you're saying that that represents no finding.
Yes.
Okay.
And briefly returning to the due process issue, I would point out that Mr. Harwick also had an appeal of the timeliness of his notice of appeal. And although the decision on that is not within our record, we can presume that he was successfully able to represent himself in front of the tribunal to the extent that he got a decision on timeliness in his favor, because if he had not, that would have been the end of the appeal and we would not be here today. So I think the record very clearly demonstrates that Mr. Harwick was able to competently represent himself. He presented his case to the ALJ, he explained his position, and the fact that a person doesn't prevail doesn't mean that they weren't able to represent themselves or that their right to due process was violated. I think Mr. Harwick did have notice that he could have counsel. And I think the point about, well, he said he'd already explored the resources that were available and he had not been able to find anything. If the ALJ had said, okay, well, I'm going to continue it for more time, then Mr. Harwick would have been denied the right to have his hearing go forward and get the determination that I'm sure he was anxious to get. So I don't believe that he has established any violation of his due process rights here.
I just have to come back to a question Judge Jacobs asked you. And if the department and the board said he may have had an ongoing relationship, but that was not enough to constitute rendering services, how do we not treat that as a finding that supports the underlying allegations? They appear to have adopted the underlying allegations and say that may be an ongoing relationship, but not rendering services. Walk me around how that's not a finding.
I think I must have misunderstood the question, Your Honor. My assertion was that that's not a finding, a fact one way or the other as to whether he was doing the things that he said he was. It is absolutely a legal finding that he was not performing services.
But isn't it adopting as true and saying even so it's not providing services when they say that? Or are you just saying that the board erred and just simply didn't make the finding it needed to?
So the exact language of that is he may have had an ongoing relationship with the employer. So the word may signifies that I'm not, it says this might have been true, essentially. And I absolutely agree that the board was making a finding that for purposes of the statute, he was not performing services, even if this was true. But I think that's essentially assuming arguendo is maybe.
And that's where I'm at. If they have to have at least, if they're not going to say, we don't find these three things happen, if they say he may have had a relationship, they are adopting as true for the purposes of that discussion what it is that he said happened and saying it doesn't meet the standard of rendering services.
I think that is correct. We thought that the board was saying, assuming this is true, it still doesn't change the legal result. But I don't think that's the same thing as them making an express finding that it's true. And I still have a bit of time remaining, but unless the panel has any further questions,
I think we're good. Thank you.
thank you very much, Your Honors.
You're 34 seconds away.
34 seconds, Your Honor, so I don't have, I'd be happy to answer any additional questions, but don't have anything further if there are none.
I think we're good then. Thank you, counsel.
Thank you, Your Honor.
All right. We appreciate the argument here today and that you folks were well prepared for it in answering our questions. We're going to take the matter under advisement. We'll issue our ruling in due course. And with that, we're going to stand adjourned.